Good afternoon. I hope you guys have had a good session this morning. I'm looking forward to an exciting afternoon. It's my distinct honor to introduce our speaker this afternoon, Ramogi Huma. Ramogi and I are friends. He was a guest lecturer at least once or twice at my class at Pepperdine a few years ago. And he himself, he's a player. He was a former UCLA football player who played in the '99 Rose Bowl team. Unfortunately for us Bruin fans, Wisconsin won. But he played from, I think, 95 through 98. And he founded and is the executive director of the National Collegiate Players Association, which is a 501c3 advocacy group comprised of over 20,000 Division I college athletes from over 150 campuses. He has held numerous meetings in Washington and state capitals around the country, and he, I believe, led the effort a few years back with the Steelworkers Union when they were trying to get recognition for the collegiate players as a union. He's an incredible and inspirational speaker, and he has single-handedly moved this ball forward. He has provided the Justice Department with a lot of assistance in the various investigations that the division has had, including the NCAA's one-year scholarship limit, as well as a consultant on the athletes' rights antitrust cases in White versus NCAA, Agnew, the O'Bannon, and the Jenkins case. A number of these cases continue, but a lot of what we're seeing in some of the changes and the debate with respect to athletes' rights is as a direct result of Ramogi's efforts and a number of folks. Ramogi, please join us on the stage, and I want to welcome you to the Justice Department and thank you for your efforts here.
Thank you very much. Good afternoon. First, I'd like to thank the DOJ for having me here today to discuss antitrust issues in college sports. I'm here today because NCAA sports is a predatory economic cartel that treats players like university property rather than people. The NCAA does nothing about the seriously injured, abused, and dead college athletes. Instead of action, the NCAA states loudly that it has no duty to protect college athletes. In fact, it ruled that Michigan State University team doctor Larry Nassar's multiple sexual assaults against Michigan State athletes did not break NCAA rules, simply because there are no NCAA rules that prohibit the sexual or physical assault of college athletes. But if any of those abused athletes would have dared to benefit from the economic rights afforded to everyone else, the NCAA would have spared no expense to investigate and punish them. That's because the primary role of the NCAA sports is price-fixing athlete pay. College sports is a $14 billion a year industry produced by 500,000 college athletes who are denied economic rights and freedoms that would otherwise be allowed, that will allow them to receive an equitable portion of their hard work. College athletes are workers who, to this date, have no workers' rights. Meanwhile, colleges capitalize on their athletes' blood, sweat, and brain damage to generate multi-billion-dollar TV deals, multi-million-dollar apparel deals, coaches' contracts, and invaluable marketing. However, the NCAA imposes extreme player compensation restrictions that are economically harmful to tens of thousands of college athletes and leave over 80% of college athletes below the federal poverty line. This NCAA price fixing is counter to Americans' principles of free enterprise. In addition, there's a strong civil rights concern given that African Americans comprise a disproportionate percentage of athletes in the revenue sports of football and basketball, yet suffer the lowest graduation rates. The public is well aware of these glaring injustices. A recent poll found that 84% of regular college students and 89% of college athletes feel that NCAA sports exploit college athletes. The poll also found that college athlete name, image, and likeness compensation was favored by 77% of regular students and 81% of college athletes. Additionally, a Rasmussen poll in March found that 2/3 of Americans support college athlete compensation for use of their name, image, and likeness. And economists understand as well, 92% of those surveyed by the University of Chicago said that the system generates rents for colleges at the expense of their athletes. Current and former college athletes have stood up against the NCAA's illegal price fixing rules in key lawsuits. Players proved in both O'Bannon versus NCAA and Austin versus NCAA antitrust lawsuits that the NCAA has been illegally price fixing player compensation. However, the courts have allowed ongoing price fixing for compensation that isn't tied to educational costs. Austin versus NCAA is a current case and has been appealed to the Ninth Circuit. The NCAA is hoping to overturn the current ruling, and the plaintiffs are appealing for broader relief. We agree with the plaintiffs 100%. NCAA cartel conduct continues to flaunt antitrust laws, and unless this ruling is expanded to provide broader relief, the NCAA will continue to price fix players' compensation. The NCAA has attempted to justify its mockery of antitrust law. During the O'Bannon trial, the NCAA's lawyers stated that the NCAA is a cartel that does good things, rather than a cartel that does bad things. College athletes beg to differ. I started this organization after my teammate was suspended for eating groceries that were left on his doorstep when he was broke and hungry. The NCAA suspended him because it said he only received the food because of his athletic name and prominence, which is a violation of NCAA price fixing rules. Meanwhile, the NCAA was fully capable of capitalizing off of his name because they were selling his jersey in the store. NCAA's assertions that it only imposes well-intentioned price fixing have been exposed as false. I've made handouts available on the table to refute these NCAA arguments with facts and data. But at the end of the day, our nation's antitrust laws and principles of equal rights can't be subject to whether or not a cartel thinks its illegal activities are well-intentioned. Another antitrust issue of great concern is that the NCAA facilitates collusion to restrict players from transferring from one school to the next. The NCAA actually gives players' current schools veto power over transfers. Additionally, college athletes that participate in football, basketball, baseball, and ice hockey must sit out a year after they transfer, while other sports do just fine without this penalty. Essentially, and with few exceptions, the NCAA imposes a national collusive non-compete agreement against players. My organization, the National College Players Association, believes that all players should be able to transfer one time in cases of abuse and when a head coach leaves without NCAA punishments or non-compete restrictions. In 2005, the collusive agreement harmed University of Illinois women's basketball players who publicly detailed various forms of abuse by holding them out for 6 games after they fled to another college. This summer, the agreement harmed University of Illinois football player Luke Ford, who was denied a transfer waiver. Ford transferred from Georgia, where he could have been a starter, to the University of Illinois to be closer to his ailing grandfather, but the NCAA denied his request. The NCAA has taken it upon itself to determine that his grandfather's poor health isn't a good enough reason to transfer, since his grandfather is not part of his nuclear family. The NCAA also denied the transfer waiver request from Virginia Tech football player Brock Hoffman, who transferred from Coastal Carolina to help his ill mother. Apparently, her brain tumor, impaired vision, facial paralysis, and hearing loss did not outweigh Coastal's claim on Hoffman's labor. Both Ford and Hoffman would have been free to participate if all athletes were allowed to transfer one time without punishment. The collusion to restrict player transfers comes at a great physical toll to college athletes. The NCAA's own survey found that 50% of Division I athletes, or the athletic trainers, knowingly return players with concussions to the same game. This is horrific, given all that we know about chronic traumatic encephalopathy, also known as CTE, a brain condition linked to contact sports that can bring on memory loss, impulse control, depression, and suicide. The National Athletic Trainers Association found that almost 60% of athletic trainers are pressured by coaches to make medical decisions that are not in the player's best interests. 6 medical associations jointly published a team physician consensus statement declaring that college athletic staff have a financial conflict of interest that puts players' health at risk. Players should not be trapped at abusive or negligent athletic programs because of NCAA transfer restrictions. This environment contributes to a lifetime of medical expenses, as 50% of former college athletes suffer chronic sports-related injuries. All of this underscores the need to end NCAA collusion that takes away players' freedom to transfer. Included among the harmful collusion in NCAA sports are rules to stifle players' eligibility to secure legal representation, aka sports agents. Murderers. Murderers are guaranteed the right to full legal representation in America, but college athletes are not. The NCAA also blocks players' ability to complete their college athletics eligibility, even if those athletes reject a professional league draft offer. However, the NCAA has already demonstrated that the industry can function just fine with less restrictive alternatives. For instance, high school recruits playing baseball and ice hockey can have sports agents, and the NCAA adopted a new rule to allow men's college basketball players to do the same. As for professional drafts, baseball and ice hockey players who are drafted out of high school are allowed to play in NCAA sports if they choose to decline their draft opportunity and play in college instead. The NCAA's new rule also allows men's college basketball players who enter the NBA draft and are not drafted to stay in college and complete their NCAA eligibility. The collusion that prevents players of all sports from exercising these freedoms cannot be justified when it's been demonstrated as unnecessary in various sports currently within the industry. If the NCAA truly wants college athletes to be treated like regular students and graduate, then it should allow them to secure legal representation and stay in college. Clearly, the NCAA and its colleges have been bad actors when it comes to the treatment of college athletes. To date, college athletes have been forced into second-class citizenship. No other college student risks a group boycott by thousands of colleges for daring to earn money or transfer. This takes place in one of the most high-profile industries on the planet, right before our very eyes. Fortunately, developments among some state legislatures may bring impactful reform in some of these areas. My organization, the National College Players Association, is a co-sponsor of California Senate Bill 206, the Fair Pay to Play Act. The Fair Pay to Play Act would allow all California college athletes to secure sports agents and receive compensation for use of their name, image, and likeness, without punishment from their college, conference, or the NCAA. The bill has complete bipartisan support and was approved 72-0 in the Assembly and 39-0 in the Senate. It's now on the governor's desk. Legislation similar to California's Fair Pay to Play Act was introduced with bipartisan support in the state of Washington, Colorado, and the U.S. House of Representatives. Most recently, a name, image, and likeness compensation bill was introduced in New York, and state lawmakers in South Carolina announced a commitment to introduce a similar bill in the upcoming legislative cycle. My organization will do all it can to make sure that this bill gets introduced in as many states as possible. In response to the California Fair Pay to Play Act, the NCAA submitted letters from its leadership essentially threatening California with an illegal national group boycott in which all other NCAA colleges would be prohibited from competing against California colleges. You can bet that the NCAA will make the same threat against other states as well. Such action would be a violation of both federal and California antitrust laws. Neither the U.S. Congress nor the state of California have granted the NCAA an antitrust exemption that it would need to take such action, nor should they. The NCAA is signaling that the Dormant Commerce Clause would render the Fair Pay to Play Act unconstitutional. It points to a precedent in Miller versus NCAA, a court ruling that the NCAA won regarding its due process rules. However, the 1992 Miller versus NCAA ruling examined uniform NCAA due process rules and does not apply to today's non-uniform player compensation arrangements that exist throughout NCAA sports. One of the pertinent questions to ask about the Dormant Commerce Clause is, one, does the Fair Pay to Play Act discriminate against other states? The answer is no. The bill does not attempt to require out-of-state colleges to allow player compensation, nor does it prevent other states and colleges from choosing to allow player compensation. It does not prohibit California entities from competing against out-of-state colleges or participating in NCAA sports, and it does not exempt California entities from complying with the provisions of this bill. The second question asked is, does the local benefit outweigh any industry burden? The answer is yes. California has a vested interest and compelling interest in ensuring college athletes have equal rights to legal representation, economic freedoms, and antitrust protections afforded to other students and residents in the state. This bill would not create an industry burden. It does not require colleges, conferences, and athletic associations to compensate players. It would reduce industry regulation by decreasing the burden of complying with and enforcing NCAA compensation prohibitions? And the third question to ask is there a need for uniform player compensation in NCAA sports? The answer is no. Player compensation in NCAA sports already varies dramatically. For example, the Ivy League, a Division I conference, prohibits athletic scholarships, while other Division I colleges provide 5-year athletic scholarships. This means that a player at an Ivy League college receives no money, while a player on a 5-year scholarship at a private school can get over $300,000. And yet these two economic systems compete on the court every March without harming demand. The NCAA also granted the Power 5 conferences autonomy to make many of their own rules for player compensation, while denying other Division I conferences the same autonomy. There are also tremendous differences in player compensation amounts among players on the same team. Teammates can receive a full scholarship, partial scholarship, or no scholarship at all. And some players are permitted to receive Olympic prize money, like the University of Texas swimmer Joseph Schooling, who won $753,000 in 2016 from his home country of Singapore for winning a gold medal. The NCAA does not claim that all of these differences in player compensation is a burden on its industry. In conclusion, it's my hope that this is the beginning of a continued dialogue with the US DOJ Antitrust Division about serious antitrust issues in NCAA sports. Specifically, the National College Players Association would like the US DOJ to consider the following actions to protect college athletes and uphold the integrity of federal antitrust laws. First, to file an amicus brief in support of players in Austin versus NCAA. Second, open an investigation into the possibility of challenging NCAA restrictions on players' transfer freedom, their ability to secure sports agents, and their ability to decline a draft position to complete their college sports eligibility. And three, open an investigation into the NCAA's public threats of an illegal boycott against California colleges over the Fair Pay to Play Act. Thank you all very much for having me.